propriety, rationality, proportionality. When this court retires, we pray that you are going to consider those four principles. This process, as has been brought out by the first petitioner, do they meet the tests of legality? Do they meet procedural propriety in whatever guise? Does it mean rationality? Again, Professor Gender should be familiar with Wednesbury degree rationality. That's a test.
Counsel, address the court, not the academy.
Most obliged. Most obliged. Most obliged. If I veer into the academy, please forgive me. Most of the time, I veer towards the academy. Wednesbury rationality. Has the Wednesbury rationality test been met in terms of this particular impeachment process? Proportionality. Look at the allegation on, for example, what was said and what ought to have been referred to the NCIC, the National Cohesion Committee. Was that proportional? Does it meet the proportionality test? And on that very issue, Senior Counsel Paul Buite submitted to it. There's the principle of subsidiarity that is captured under Section 15 and Section 26 of the NCIC Act. Parliament ought to have deferred to the authority of the NCIC on the allegations made against the Deputy President. NCIC ought to have made the primary decision on the gravity or lack thereof of what was said. So the assumption of Parliament without going to the NCIC is not only illegal and unconstitutional, it also offends the principle of subsidiarity. When Parliament conducted itself in the manner it conducted itself, Parliament acted as the Hobbesian Leviathan. It became the investigator, the prosecutor, the judge, and the jury. This violates Article 47, principles of fair administrative action, and judicial action, quasi-judicial action. Procedural fairness protects the people, not just the office holder. Impeachment is often framed as an accountability of one individual, but constitutionally, impeachment protects the voters who elected that office holder. If procedure is absent or conducted in the manner it was conducted in this case, the electorate's choice can be overturned by unregulated political processes. This weakens popular sovereignty, a core constitutional value. Thus, the real victim of procedural failure is democracy itself. Whereas it protects, there are protections for the individual, the real protected target is the core principle of popular sovereignty. 5, the absence of procedure invites a constitutional crisis.
Why? Because without procedure, courts are forced to intervene, parliaments
claim political privilege, the executive legitimacy becomes contested. We have a deputy president who did not come through the ballot. That's a legitimate question. Institutional conflict arises between the arms of government. And this leads to the usual talk, judicialization of politics, politicization of constitutional processes, public loss in institutions. A constitutional democracy cannot survive when removal of national executive and office holders lack legitimate legal guardrails. 6, separation of powers demands legal boundaries. Parliament has the power to impeach, but not without limits. Parliament becomes a judge in its own course without procedural law. Checks and balances collapse. Majority power replaces constitutional restraint. Remember, we are a state under constitutional restraint, not abundant political power. The way in which this impeachment process was conducted contradicts the idea that constitutional supremacy restrains political majority. That is something we will invite you to find. The rules of natural justice, there are 3. the right to be heard, freedom from bias, and those have been submitted to. Then there's the third rule, the rule in R versus Sussex, Justices Ex parte McCarthy, 1924. And this rule, as articulated by Lord Justice Hewitt, simply says this, that justice must not only be done, but manifestly and undoubtedly it must be done. Justice must not only be done, but manifestly and undoubtedly it must be seen to be done. In terms of this process of impeachment, the process has continued when the substantive subject of impeachment was in hospital. He did not have the opportunity to rebut or to respond to the charges. In terms of the third rule, the first two were submitted to. I focus on the third rule. R versus Sussex Justice Magistrates. Justice must not only be done, but must be seen to be done. Do we see justice to have been done in this context when somebody was sick in hospital and processes continue without him being present? It's a problem. President danger, today's deputy president, tomorrow's democracy. If impeachment can continue and happen in such a shambolic manner that it happened, future removals will be done and can be done more easily. The threshold for removing elected leaders becomes political convenience. My brother Ochiel gave us the history. I don't want to go through it. Political convenience brought us to where we are in terms of shielding the office of deputy president. Executive stability becomes fragile. This transforms impeachment from a constitutional safeguard into a political weapon. Is that what we want in terms of this court? In terms of the jurisdiction of this court, I have completed with the rules of procedure. I want to go to the jurisdiction of this court. The High Court has 4 jurisdictional capacities under Article 165. The High Court has original jurisdiction, appellate jurisdiction, supervisory jurisdiction, and writ jurisdiction under Article 165. At play, particularly with regards to the matters before this Honorable Court, are the supervisory jurisdiction and the writ jurisdiction of this court. The supervisory jurisdiction becomes particularly important under Article 165(6), when supervising quasi-jurisdictional capacity of various arms of government. And this is where the court will invoke its judicial review power or judicial review authority. What is judicial review? Judicial review has 2 limbs to it. Judicial review is the primary judicial function to preserve legal order by confining the political branches to their proper limits of power under the Constitution. That's the first limb. The second limb is protection of private individuals by preserving or preventing illegal encroachment on the rights of these individuals. Those are the 2 capacities of judicial review. And when the High Court, under Article 165 of this Constitution, stands as the primary guardian and interpreter of the Constitution and its values, the court exercises broad authoritative jurisdiction, including supervisory and constitutional oversight over the National Assembly. So that the National Assembly will not be hard to say that this is a political question beyond the reach of the court. This court, the breadth of its constitutional and supervisory jurisdiction is a capacity granted by the Constitution, and it's not an intrusion into the domain of the legislature, and is a necessary feature of constitutional design. I hear telepathically, and I can almost predict that you will hear this from the respondents, that Parliament has its right to formulate its own procedures. If the courts will be inclined to find it that way, we have provided to you a case, Maneka Gandhi versus Union of India, 1978. And it presents to this court a test. The Supreme Court of India, interpreting Article 21 of the Indian Constitution, speaks of due process in this manner. It says, number one, that procedure as a capacity of due process must be established by valid law. That is condition precedent. That condition adds on to say that even if the procedure is prescribed by law, it should be fair, just, and reasonable. Fair, just, and reasonable. So when you retire to write your judgment and you're satisfied that there was a modicum of procedure, you will have to look at that procedure in terms of the Maneka test. Was that procedure fair? Was it just? Was it reasonable? Was it reasonable to continue with the process when somebody is at the current hospital getting treatment? That is a question you will have to answer. In conclusion, a determination of impeachment is not a routine judicial exercise. It lies at the crossroads of law, constitutional governance, and the stability of democracy itself. La santé de notre politique, as the French say, the stability of democracy itself. The court's voice in this moment is not confined to the litigants before it, but resonates to the nation and future generations. This is a modern moment. Your judgment will either confirm that constitutional authority is bound by the discipline of law, or suggest that the most serious constitutional processes may unfold without the safeguards of the Constitution as required. By carrying out this solemn responsibility, the court protects the supremacy of the Constitution, sustains public confidence in democratic institutions, and ensures that the exceptional power to remove a constitutional office holder is exercised strictly within the confines of the rule of law. Nunca más, never again, should we go to the dark old ages. I submit. My brother Sakimpa joins in next.
Thank you.
Yes, Your Lordships and my lady, my name is George Sakimpa. We do appear together with Mr. Ogada for the 4th to 8th petitions. Your Lordship, the petition that is before you is originally Kerugoya petition E015, and which has since been consolidated in these petitions. So, Your Lordship, I will only deal with 2 issues, because I do not wish to regurgitate what my seniors have already said. So, Your Lordship, I will just handle 2 issues, the first one being on the element of public participation, and it is going to be in twofold. That is from at the impeachment level, and secondly, public participation in terms of the appointment of the Deputy President, Professor Kithure Kindiki. And the second issue, Your Lordship, is on the Senate, and whether it was open for the Senate to apply the plenary route. So, Your Lordship, I will start with the first issue of public participation. Your Lordship, the principles of public participation have already been eloquently espoused here, especially the BAT Supreme Court case. So, Your Lordship, I will not delve into that, other than to add that there is an international association for public participation, which has since developed at least 7 core principles when it comes to public participation. Your Lordship, Kenya, under Article 2.5 of the Constitution, general principles of international law do form part of Kenyan law, and therefore we do rely on those provisions. And there are 7 principles, and basically they have been well captured in the Supreme Court case of BAT. So, Your Lordship, so I would not wish to mention the 7 of them, other than to be referring to them when it is necessary. So, Your Lordship, the most important element of this public participation is that it has to be qualitative and quantitative. So, Your Lordship, what I'm going to do in these short submissions is to go to the evidence and to actually demonstrate that the public participation exercise that was conducted on 4th and 5th of October 2024 were neither qualitative nor quantitative. So, Your Lordship, I will begin with the affidavit that was sworn by the 4th petitioner, that is Honorable David Munyi Madenge, where, Your Lordship, in that affidavit, he says that he had no opportunity at all to participate in terms of echoing the views. And what was the reason for his inability to air his views? Your Lordship, the reason is that when he went to the designated center, Your Lordship, that center was closed. First of all, Your Lordship, the center was not open. It was closed, and there are evidentiary documents that were attached to his affidavit to confirm that that venue was closed. And that is what he has deponed in his affidavit, to the effect that he did not participate at all, because all the residents of Kirinyaga in that instance who went to that particular station did not participate. They dispersed without having given their views in terms of the impeachment of the second deputy president. So, Your Lordship, the next issue is on the issue of the notice. Your Lordship, from the notice, especially the extension notice of public participation, that notice was pursuant to the orders that were issued by Honorable Justice Richard Mongo in a petition that was earlier filed, and where the judge said that the modalities that were put by the National Assembly were not sufficient, and therefore ordered for a second phase of public participation. So, Your Lordship, what the National Assembly did, instead of going back and preparing for a proper public participation as was ordered by the judge, they simply extended the public participation. Your Lordship, from the annexure that we filed, that is DMM1, Your Lordship, the notice is actually dated the same day when the extension was actually supposed to happen. So, from the daily newspapers that were filed, Your Lordship, it was on the very same day, that is on 5th of October 2024, telling the public that we have extended the public participation. So, Your Lordship, that notice was not enough, and even from the affidavits that was sworn by the 5th, 6th, 7th, and 8th petitioners, Your Lordship, they do confirm that they came to realize that the extension was given after, in fact, on the next day. So, in short, Your Lordship, because I don't want to repeat what my colleagues have already said, it is our humble submission that this court return a finding that indeed the notice was not sufficient for a meaningful and qualitative public participation. So, Your Lordship, on the other issue of quantitative aspect, my learned senior, Mr. Tom Masharia, had given a percentage in terms of the qualitative aspect, that out of 50 million Kenyans, only 200,000 gave their views in respect to the impeachment of the second deputy president. So, Your Lordship, that translates to 0.04%. And that is what basically said it's still 0%. So, Your Lordship, it was not quantitative and it was not qualitative. And Your Lordship, I only want to mainly emphasize on the decision that we filed, Law Society of Kenya versus National Assembly, 2025. where, of course, the court, in agreeing with the BAT case, the court said that public participation must be real. It is not a cosmetic or a public relations act. It is not a mere formality to be undertaken as a matter of course just to fulfill a constitutional requirement. There is need for both quantitative and qualitative components in public participation. So, Your Lordship, I have already submitted that it was neither qualitative nor quantitative. So, Your Lordship, I want to go now to the next issue in terms of the public participation in respect to the appointment of Professor Kithure Kindiki as the Deputy President. So, Your Lordship, and I'll be referring to the memorandum that was signed by the President. And Your Lordship, we have it in page 1 of the affidavit that was sworn by Honorable David Madenge. It is page 1. So, and the document is a presidential memorandum of nomination by His Excellency the President William Ruto to the National Assembly. And it says that whereas pursuant to Article 150 of the Constitution, a vacancy has arisen in the office of the Deputy President. So, Your Lordship, in relation to that, our submission is that this nomination of Professor Kindiki was subject to the Public Appointments Parliamentary Approval Act, that is Cap 7F of the laws of Kenya. And Your Lordship, in respect to this particular act that I'm referring, the Presidential Memorandum of Nomination is substantially in compliance with the provision of this act, except on the element of public participation. That is where the National Assembly drew the line, that the memorandum of did comply substantially with the act, but they chose not to undertake public participation. And I will start with the objective of this act. So, and the act says it is an act of parliament to provide for procedures for parliamentary approval of